Nashville and Davidson County, Tennessee, et al.
Good morning.
Your Honor. Jim Roberts on behalf of the appellants in this matter. It's nice to be back in open court.
Good morning. We're glad to have you back.
To reserve 3 minutes, if I could, please.
3 minutes, Mr. Roberts. Yes, sir.
Your Honor, this case is on appeal for the second time, and there are really two issues that we like to bring up to the court. We've tried to narrow this appeal as much as possible. We don't believe that there was a final order at the trial court, so the first issue is simply that the trial court failed to address the critically, if not central issue of this case, which was the establishment of a reasonable mechanism. That reasonable mechanism, the term of art, is required by a charter amendment brought forth by the people back in 2011, and it was required by Metro's own legislation, 2017-910, and it very clearly set out that there had to be a reasonable mechanism to protect the charter amendments, protect the events protected by the charter amendment. And we're talking about the Fairgrounds, and that charter amendment for 2011 protected what we call the existing uses, all the expo events and the flea markets and things like that. And so the Metro Council recognized it had a duty on the Fair Board for the Fair Board to protect those events, and it put forth this language that said there had to be a reasonable mechanism.
By saying that there needed to be a reasonable mechanism, does that mean that those events that are preserved by the charter amendment always have to take precedence?
Yes, Your Honor, it does. It means because the Metro Charter says that they have to do these events.
Well, then, so why couldn't it just have said that these existing events will always take precedence?
Well,
you don't really need a reasonable mechanism of any sort, do you?
That's a great question. And the reason it's required, I think Metro Council was recognizing its duty to have a reasonable mechanism so that it would be required. If you look at the language of 2017-910, it says there has to be a reasonable mechanism for resolving scheduling disputes, because they knew the way this works is the Fair Board has its events scheduled years in advance. There's meaning 3 to 5 years in advance, and then MLS's schedule would come in much later in the season, and so that MLS would create scheduling conflicts by its decision to hold games on certain dates. And so there had to be a mechanism that allowed the Fair Board to hold those soccer games and protect the events. And in the end, Your Honor, I believe the Fair Board's duty under the charter to the existing uses takes precedent. It doesn't mean they can't work together. It doesn't mean that there can't be a reasonable accommodation, but much like all sorts of relationships, someone has to be able to make the decision. And that is what we spent almost 2 years trying to litigate, is who has the authority to make decisions here.
Can you spend some time walking through the mootness analysis in this case? I am trying to, let's say we agree that Section 10 of the lease doesn't come up to snuff under the charter. What relief can this court?
What does it all mean?
Yeah.
So Section 10E was what I believe was the attempt, but it's got a problem. That's in the stadium lease. And that stadium lease, Section 10E begins to talk about how people work together. Here's the problem in a nutshell, and I would ask this court to ask the appellees this. All of the discussions mandated by Section 10E are between the Fair Board's executive director and Walsh Management. And every shred of proof at trial says that Walsh Management has no authority whatsoever to resolve any scheduling disputes. And that's the problem. That's the crux of this case. And our efforts throughout I know it's an extensive record, we're trying to figure out what was Walsh Management's authority, because Walsh Management is the entity that operates the stadium. They do not control the team. And in fact, Walsh Management's executive director, corporate designate, even admitted MLS sets their own schedule. They have no authority to adjust that schedule. They have no authority. All they really have the authority to do is beg. So when you look at Section E, it talks about the different events and how they're going to try to work together and how they're going to, but the problem with it is Walsh Management has no authority to negotiate anything. And the Fair Board has no authority because it gave away that authority in the RNDA, which is part of the second part of the argument. So we have two entities. We have a Fair Board and Walsh Management who are tasked with having a reasonable mechanism, and neither one of them has authority to do anything. That's the problem with Section 10E.
So what would you have us order on remand then?
Well, I think the proper thing for this court to do, Your Honor, is to remand it back to the trial court for a determination if there's a reasonable, where is this reasonable mechanism, and have a clear ruling on that.
And if the trial court accepts your argument, what would the trial court do then?
Well, Your Honor, I think what the trial court would do and would have to make a determination, which is lacking from the trial court's order from October 2020, of who has the authority to, what authority does the Fair Board have? And Chancellor Lyle said the Fair Board, the Metro had the duty to come forward with the proof. Where is the proof that the Fair Board, after all these contracts are entered, has the authority to protect the charter amendments under 602? Do they have that? They have to have that authority under the charter itself, but they also have to have it under this Metro substitute resolution. They have to have it. Where is that? And there's nothing in this order that addresses that. And we even filed a motion to alter amend asking the court to address it. There's nothing that addresses that authority. So if there's a conflict, if MLS says we're going to have a game and it conflicts for whatever reason over the next 75 years, it conflicts with a Fairgrounds event, who gets to decide who does the accommodating? And we submit, Your Honor, that the charter says Fair Board has the authority. Resolution 2017-19 says there has to be a mechanism for the Fair Board to protect its own events. And quite honestly, the person who has to do the accommodating is MLS, the team as identified.
With regard to the reasonable mechanism issue, what particularized injury has your client sustained due to the absence of this finding?
Well, it is an ongoing. Well, it is. I'm not going to answer this exactly right. It is an ongoing injury to the flea markets, to the expo events, to all of the citizens of Davidson County, because all of those events, and we've seen this in the last month, that the citizens count on and enjoy are now in jeopardy because there's no way for the Fair Board to protect them. We know that exotic pet show was canceled from MLS.
How does that affect your client or clients?
I'm sorry, Your Honor.
How does that affect your client or clients?
Well, the remaining parties are the Fairgrounds Vendors Association, Flea Market Vendors Association. Those are, Your Honor, I think they're all affected because it takes away, I don't think the best way to say this, a community resource that they work to protect. I mean, part of the whole Save Our Fairgrounds organization was set out to protect the fairgrounds from just this sort of abusive development. The charter amendment was sponsored and voted on by 72% of the people to stop this sort of without certain events taking place. And so for the council to come in, and the council recognized that. That's what 2017-9-10 is about. They didn't just put this in a vacuum. It was designed to ensure that the Fair Board could fulfill its duties, and Metro could fulfill its duties to protect those events.
Counsel, you're treating same-day events as inherently a conflict, and that doesn't seem to be how the trial court viewed it. It seemed that you could have a soccer game there that day, and you could have other events on the fairgrounds that day. So there's not necessarily an inherent conflict just because there's a soccer game scheduled. In fact, it may increase traffic for the vendors, for the flea market.
Your Honor, it might very well do that. The problem is, what if it doesn't? And because of the way the RNDA is written, the MLS has priority scheduling over the field. They have priority, that leads to priority parking.
But wouldn't you know something about like that only after the fact? So how do you, the vendors come in and the hooray, the soccer game was here, we had more traffic than we never had, our sales were amazing, or after the event they would have to say, everybody went to the soccer game and went home immediately after and it totally ignored us. I mean, you wouldn't know that until after the fact, though.
Well, I think, first of all, we have a 75-year window to sort of judge the effects of these things. So quite honestly, there might have a divisional fair and say, hey, we'd like to have a soccer game in the middle. Over the last 100 years, there have been a number of events that, during the state fairs, not during, there's a lot of flexibility to this. But what happens if they figure out that it doesn't work? What happens when the Fair Board says, look, having soccer games in the middle of Christmas Village is not an effective use of the Fair Board. It doesn't protect our existing uses. I'm not saying they can't make a mistake, and I'm certainly not saying they couldn't do it to the benefit of everyone. but someone has to be able to make a decision in the end. And I submit that the charter says that someone is the Fair Board, and that Resolution 2017-910 says there has to be a mechanism so that the Fair Board can protect its events within its own discretion.
Counsel, following up on Judge McBrayer's question, these what ifs, what if it worked this way, what if it, those seem to point back to justiciability concerns in this case, whether we call it standing, whether we call it ripeness, the facts aren't adequately developed to be able to know, because we don't know what these injuries are actually going to look like. And the trial court didn't seem to be very impressed that there were going to be injuries in this case. Don't the what ifs really just return us to there's an underlying justiciability problem in this case in terms of standing, whether there's actually a sufficiently concrete and particularized injury here in this case that's been suffered?
Well, yeah, we relied in bringing this suit on the legislature's enactment. I apologize, I can't think of the statute that said anyone that was affected by it would have the standing to come forward. I know that there's been some case law about individualized injuries, but we do have the Save Our Fairgrounds group as a plaintiff that brought forth this charter amendment and whose rights under that charter amendment are being affected. We also had the Nashville Flea Market Vendors Association who have this, if I got the name right, has their flea markets are being affected. What we're afraid of is exactly what happened on October 2nd, which is there is an expo event or flea market that happens to be on the same day as a soccer game, and suddenly their event gets canceled. And I know that was all in the news, and that's actually not part of the record except for the motions that we filed. But that's the sort of thing that we're concerned about. Your Honor, I believe that there's certainly Chancellor Lyle believed that they had standing to proceed with this and to bring forth their case. And I just believe that was well established by the testimony at trial. The second part of it, though, I do want to mention is that there were really two issues that we focused on, and the second is the interpretation of the charter amendment itself. I mean, I'm not giving it much hay here, but the charter amendment itself talks about the two conditions that are necessary for any sort of redevelopment, demolition of the property. And as shown in our brief, for an extended period of time, that was interpreted to mean that both a vote of the council and a charter amendment was required.
But the language provides or, right, counsel? And the language is or, not and, in terms of that provision.
Well, yeah, so our frustration with Chancellor Law was that she looked at it as being unambiguous, but then proceeded to interpret it the exact opposite of what both parties had interpreted it for almost a decade. And so I know I've just run out of time, but that for a long period, as evidenced by statements of public officials and their own ordinances, it was interpreted to mean that both were required until it was convenient to not have a requirement of a referendum. And we think this court, if it could address that, if it decides not to remand on the issue of the reasonable mechanism, should go ahead and address that, because that referendum is still important.
All right. Thank you, Mr. Roberts. We'll hear from you again on rebuttal. Good morning, Mr. Halou. Welcome.
Before I start, I'd like to use 7 minutes of our allotted time. Ms. Fox is going to be using the other 8.
Very good. 7 minutes. Thank you.
Good morning, Your Honors. My name is Will Halou, and I'm here on behalf of the intervening defendants, Nashville Soccer Holdings, LLC, and Walsh Management, LLC. For the sake of the argument today, I'll be referring to both as Nashville Soccer because the distinction between the two just isn't relevant today. The case before you is not the case that was brought in the trial court. The case in the trial court was about whether or not the soccer district could be built. The case was to halt that construction before it started. The case before you today is coming after the soccer stadium has been built and is tangentially related to the operation of it. So as Mr. Roberts stated, the first issue before the court is whether the trial court erred in not explicitly addressing whether there was a reasonable mechanism for resolving scheduling conflicts. Your Honors, simply the trial court did not err by failing to explicitly state whether there was a reasonable mechanism because it wasn't asked to. There is no mention of RS 2017-910 or the need for the reasonable mechanism in the operative complaint. There is no mention of it in the draft pretrial order that the trial court issued for comment upon by the parties. There is no mention of it in plaintiff's objection to that pretrial order in which they got to add any additional issues that they wanted tried. And there is no mention of it in the actual final pretrial order. If you review the testimony you'll see that there is no mention of RS 2017-910 in relation to a reasonable mechanism at trial. The very first time that the reasonable mechanism argument appears is in a motion to alter or amend, and that motion was denied. Now, I think what's important to realize is what RS 2017-910 is. It is a bond authorization resolution. And I want to quote from it because I want to be very clear about what that resolution actually says. Your Honor, it starts with the language that it is, quote, a resolution approving the issuance of public facility revenue improvement bonds. Section 7 of that resolution is home of the reasonable mechanism language, and it states, the authority shall not issue or sell bonds for the construction of the stadium until the following conditions have been fully satisfied. One of those conditions appears in 7D4. The team lease shall include a reasonable mechanism for resolving scheduling disputes. The bonds have issued. Whether a condition precedent to the issuance of those bonds occurred or not, the ship has sailed. It's noteworthy that plaintiffs never asked for an injunction to stop the issuance of those bonds based upon that language. And so now we're at a point of remedy, and Your Honors asked the plaintiffs about it. What is the remedy this court could issue now as it relates to a bond issuance authorization? Are we going to unissue the bond, get everyone's money back, and try and undo it all? We can't do that. It's moot. There's nothing else to do about RS 2017-910. And Your Honors, because of that, there's no longer a live controversy.
Counsel, are you suggesting that courts can't hold governing parties or government to conditions in bond agreements, that they become unenforceable once the bond is actually issued?
Not at all, Your Honor. In fact, if there were ongoing responsibilities of the government in relation to a bond agreement, then of course the courts would be the recourse for enforcing those. What I'm saying is specifically for conditions precedent to the issuance and the selling of those bonds, that those claims need to be brought prior to the issuance. And the rules of civil procedure through injunctions, Rule 9 through permissive appeals, the stay provisions in the rules would have all allowed this party to seek to stop the issuance prior to a court opinion on whether or not that condition precedent had been met. But to come over a year after the issuance and bring that claim, it's moot. Your Honor, also I want to get to the particularized injury issue that was raised. For a bond issuance, there is no particularized injury for any specific citizen. It is, if there was an injury, one shared by the public at large. Those are the exact kind of injuries that don't give a party standing to pursue those claims. Just because they helped with the passage of a charter amendment, it does not give them an interest that gives rise to a claim. Having an interest must be concrete. There has to be a property right. There isn't one here.
Counsel, one thing that troubles me with your reading here is let's say we have in place a reasonable mechanism, everybody's happy with it, it's great, it's terrific, and then a year later, after it's been passed, it's been issued, decide, you know what, we're not going to honor that anymore, we're going to step away from it, we're going to reach a mutual agreement between the Fair Board and Walsh, and we're no longer operating under that approach. Under your reading, how would that be subject to any type of challenge?
I would have two answers to that. First, if it would need to not be a condition precedent. It would need to be either in the charter or in some other resolution that wasn't just a bond authorization statute. Second, you'd have to have a party who had been bumped, for lack of a better term. They had contracted with the Fair Board to have a flea market stall. And because of a concurrent activity, the Fair Board then told them, we're canceling you because we're having a soccer game. Then you would have someone with a particularized injury and someone with there'd be an ongoing government responsibility through that resolution or charter that could then come to a court and seek recourse. But here we don't have any of the things I just said. And it's all pure conjecture. And I'm not saying that someone can't eventually come back, but they have to have an injury. It has to be that person that I just described. Your Honors, I also want to get to something that you referred to, and that is, what can this court do at this point? I think we all agree that we can't reissue bonds. We can't unissue bonds, right? So if you send it back down to the trial court and the trial court says, okay, Your Honors, if I may conclude.
Yes, please.
If you send it back down to the trial court, what's the trial court to do at that point? If we know you can't unissue a bond, is the trial court supposed to say, I don't find a reasonable mechanism, I'm going to make one up myself and disturb the actual negotiations between the parties? Is the trial court going to tell the parties, go renegotiate something that you've already been operating under for a year? We are where we are at this point. And part of the reason we are where we are is the plaintiffs didn't use all of the tools available to them under the rules.
All right, thank you, Mr. Halou. We'll now hear from Ms. Fox. Good morning.
Good morning, Your Honors. Laura Fox, representing the Metropolitan Government. I stand before you very proud of what's going on at the Fairgrounds, very proud that we finally have a plan for the Fairgrounds that's going to make it sustainable for the next 50 or 100 years. The whole purpose of this was to create a soccer district that will not only add the new facility, the soccer facility, and of course that's been built. We've had an entire season there, but we've got the mixed-use development is being built, and it's going to generate property tax revenue that is going to be able to fund the infrastructure and keep the fairgrounds sustainable for the next 50, 100 years indefinitely. That was the whole purpose of this plan, and the whole purpose of plaintiff's lawsuit was to try to stop this activity because they misunderstood this plan that it would kill the existing uses. But that's not what happened. We still have auto racing, we had the flea market, the Tennessee State Fair has moved, of course, but the Metro government is following its duty under the Metro Charter, and we're putting on our own fair. We just had our own fair in September, and they purposefully held a soccer game at the same time as the fair so that the guests would be exposed to each other's events. So this whole plan, if you read the second amended complaint, again, plaintiffs had this misunderstanding that this is an attempt to kill the existing uses. It's not. It's an attempt to help the existing uses continue and to help them thrive, because the dilapidated buildings that the fairgrounds, the activities were being held at, were not allowing those activities to thrive. The expo building now that's paid for with Metro money is beautiful. I can't tell you how happy the fairground staff are to be able to offer this state-of-the-art facility to their vendors, to have a place that the expo can take place. It was made specifically for the state fair, so we've got livestock can be in there, and there are special stalls. There are special water systems for cleaning out the waste and then replacing it, all that. There are indoor and outdoor booths for the flea market. And the intent is that that flea market and the fair is going to be able to extend up the new roads that are being built all the way up to the soccer stadium, where you're going to have a gorgeous plaza bigger than the Davidson County Courthouse green lawn. It's going to be bigger than that. And that plaza is going to be another place that you can use for the fair and for the flea market. So all of this is this self-sustaining ecosystem that it's intended to create funding and new infrastructure. And the mixed use is going to have shops and restaurants. You know, as long as I've lived in Davidson County, some 25 years, the fairgrounds has sort of been a place you drive through and you might go to on the weekend if you wanted to go to one of the events. Now this is going to be, the intention is to have this be a 7-day-a-week event where people are able to come. I want to ask
a little bit about the operation of that ecosystem. So,
absolutely.
And there's certainly the possibility that conflicts could arise.
Yes.
In terms of resolving those conflicts, in terms of having that reasonable mechanism,
yeah.
If the parties that are sitting down and meeting and conferring have no ultimate authority with regard to changing dates for the soccer games, and a soccer game creates a problem in terms of having an event, how is that a reasonable mechanism for assessing, for resolving those disputes?
Sure. Well, I mean, if we look at the term sheet in the team lease, and that's where the reasonable mechanisms are in place, the term lease and the team lease, you have the exchange of dates, and the testimony was that the MLS is used to having stadiums where there are blackout dates. That happens across the country. So it's unlikely we're going to have that kind of conflict. But if we do, the flea market is done, the testimony was, at 6 p.m., and soccer games often don't start till 7:30. So you can always have them at a different time of day. If you do have them, so to speak, conflicting, the soccer is only entitled to 200 parking spaces out there. It's really the team's lot. The rest of the fairgrounds parking is reserved for the fairgrounds. And so that's, I think it really hurts the team if there's a conflict of that type. And so, no, this reasonable scheduling mechanism doesn't say that the fairgrounds always wins. But we have bits and pieces that, when you put it together, do constitute a reasonable scheduling mechanism. And it's worked great so far, and the post-judgment fact declaration that was submitted by Director Laura Womack shows it is working. And so all the activities, unfortunately, that were stopped by COVID, not by this development really, but by COVID, have all come back. The flea market's going great. The fair, as we say, was put on this year, even though the state decided to move its fair. But the addition of the self-sustaining ecosystem is the key to this case. The crux of the lawsuit was not reasonable scheduling. The crux of this lawsuit was their assertion that adding soccer would kill the existing uses, and that it was intended to kill the existing uses. And the trial court found, which has not been appealed at all, that that's incorrect. The trial court found that the charter allows Metro to add a new use, the soccer. That's under 11.602C. The council can add new duties to the fairgrounds. So, and that has not been challenged on appeal. The trial court found that the 11.602D, the flea market, the fairgrounds, those are going to be allowed to continue. And in fact, the new expo center was specifically built to accommodate them and to let them have them thrive. The trial court specifically found that Metro has been acting in good faith this entire time, and that has not been appealed. So we have these very narrow side issues that now the plaintiffs are saying, oh, this is what the trial was all about. And I wish it was still on YouTube, because this was a Zoom trial. It was very unusual, and I actually enjoyed it quite a bit. But it was almost a month, and we had experts, and their issue was not, is there a reasonable scheduling mechanism? Their issue was, can you still have a state fair? Can you still have a flea market? And the judge found that those experts were incredibly credible, that they were world eminent experts in this field, and they said that adding more activities on site was going to make a much more beautiful fair, and it was going to benefit the existing uses, and that there were ways to accommodate everybody. I'd like to add, of course, there can always be scheduling conflicts on a multi-use facility. It may be that the One Expo Christmas Village conflicts with the roller derby girls. There are always going to be conflicts on a multi-use facility, and so the manager is used to those things. And the testimony was, and the trial court found, everybody can work together on these things. So I think that because the plaintiffs have failed to challenge the main findings, I think this is a pretty easy case. Really, honestly, the stadium has been built. This case is moot. The whole purpose of this case, if you read the second amended complaint, was to try to stop the stadium. It's been built, and so I think that's really done. All activities, of course, are continuing. They're coexisting, and then the idea that or doesn't mean or is really without merit. There's nothing to it. That was an interpretation of an entirely different plan, where the auto racing would have been replaced by apartments, I think. And in that case, there was a legal opinion that you would have had to amend the charter, because you would be getting rid of auto racing. And if that ever happened, you can't do that without amending the charter. But that's not what this plan is. This plan is to continue everything and have everything continue for good, for the foreseeable future.
All right, thank you, Ms. Fox.
Thank you.
Mr. Roberts, your time for rebuttal.
Well, Your Honor, Ms. Fox and I agree on one thing, and that is simply that the Fairgrounds always wins. In response to your question, your question is the absolute right question. It's not about, oh, we're going to get along. It's what happens when we don't get along and there's a conflict. Who decides? And I submit, she's absolutely right, the Fairgrounds always wins. The problem is, well, it always wins because the charter says it always wins. It always wins because 2017-910 says it always wins. And the problem is there's no reasonable mechanism to guarantee that. The RNDA attached to the ground lease gives away the Fair Board's rights. That's in section 25G5, gives away the rights. The person who's supposed to be part of that mechanism, so to speak, was Walsh Management. And every shred of testimony says Walsh has no authority. So what we have is Fair Board sets its schedule, its proposed schedule to the MLS. MLS unilaterally decides when it's going to have events, and it controls the Fairgrounds. And that is absolutely violates the charter, and it violates 2017-910.
Counsel, why are the plaintiffs in this case, you're arguing the Fair Board gave away something they shouldn't have given away. If the Fair Board gave away something they should, why are your clients the right party to vindicate the interest of the Fair Board in terms of losing authority that it should have had? Why are they the right? I'm struggling to see the relationship here, the standing here that they have in this case.
I'm not sure I understand your question exactly.
So the injury, the loss of authority here is the Fair Boards, right? Yes. That's the entity that should have had greater authority to exercise, make decision making in your view, with regard to scheduling, right? That in MLS has too much control. Fair Board doesn't have enough. Why are your clients, why are the plaintiffs in this case the right party to be addressing, seeking to vindicate that injury?
That's easy because I disagree with Ms. Womack on this. The problem when we give away the field of play and we give MLS absolute control of the property, they do control the property. The 200 parking spaces are merely the spaces near the stadium. But the only thing the Fair Board is guaranteed, and this is part of Section E, is the parking adjacent to the Expo Center. And so a very large percentage of the parking, which is, if anyone has ever been to the Fairgrounds, you know, parking is not a surplus there. Parking has always been limited, and it's even more limited, and we gave away those parking rights. We spent a tremendous amount of time in the record trying to pin down these witnesses. What does adjacent mean? They couldn't even tell us what parking the Fair Board got. And so there is going to be disputes. Ms. Womack, Ms. Fox said, talking about an event on a flea market on Sunday, ends at 6, and a soccer game starts at 7. The problem is it takes 3 hours to load out the flea market. These events aren't just from their time to time, but they take load ins and load outs. There's always going to be conflicts. Can they work together? Absolutely. Should they work together? Absolutely. But there's a requirement that there be this mechanism. And you didn't hear any one of these lawyers tell you that Walsh had the authority to negotiate in good faith with authority with the Fair Board. And it's because they don't. And Walsh will never be able to do anything but beg MLS to accommodate the Fair Board. And that's not what the charter says, and that's not what Metro Council said. And I think this court should send it back for that determination. So if we have to come back a third time, it'll be clear. Thank you, Your Honor.
Thank you, Mr. Roberts, Mr. Halou, and Ms. Fox for your arguments. We'll take this matter under advisement.